You all may be seated. Mr. Walker, you brought this case before the court. What's going on?
Thank you, Your Honor. For the past year, I have been paying child support to my ex-wife, Jennifer. Currently, our daughter is in my mother's custody.
This case isn't as simple as who's paying or who's not. Mr. Walker has been paying $500 a month in child support to his ex-wife for the past year. But here's the twist. Their daughter doesn't live with either parent. She lives full-time with Mr. Walker's mother.
And I'm bringing this case...
Wait. Why is your daughter in your mother's custody?
So she was initially in my custody, but before this year I was a teacher and I got promoted to principal. But I'm now working at a school that's on the other side of town. I wanted to make sure that my daughter stay in the school that she's in because she has been there for the past 4 years. And I wanted to make sure that, well, she's been in that district for the past 4 years, and I wanted to keep her development because I agree with the education plan that they have there. So I took the job because it was more money and it was a better career for me. And
more money, so should you be paying more in child support then?
Well,
making more money?
Well, I think that I should be paying my mother the child support. Currently, I'm paying my ex-wife the child support, and I have no idea where those funds are going.
How much do you pay in child support?
So the person actually providing housing, meals, transport, school structure, and emotional care is receiving zero of the support money. Meanwhile, his ex-wife still insists that she's the one using the money for the child. That raises the central legal question here. Should child support follow the order or follow the child? And emotionally, the deeper question is, when a family situation changes, who is responsible for changing the financial responsibility? If you were in this situation, would you address it immediately or let it drag on hoping things sort themselves?
$500 a month.
Okay. Continue.
And so she's in my mother's custody right now. My mother is retired. We had the conversation. We had an amicable conversation about my daughter living with my mother because she is retired. She worked for the city of Dallas for 28 years.
She worked?
Ma'am, we do not need the extra. My bailiff, Mr. A.K.A. Fuller, he will make sure that you're escorted out of this courtroom if you cannot control yourself. Understood?
Yes, Judge.
Thank you. You may continue.
So ultimately, the main goal of this case is that I want to move the child support from my ex-wife and then start
rightfully so. There's no reason she should still be getting any type of child support payment. Ma'am, Ms. Walker, have you been reallocating these payments that you're receiving from Mr. Walker to his mother?
Yes, Your Honor. I have receipts. I have everything. I've been taking care of my child.
What type of receipts are you talking about?
Receipts for me buying her food, clothes.
This is the moment where the legal foundation begins to shift. Mr. Walker says calmly, "I don't know where the money is going." It sounds simple, but in family court, those words are powerful. Because child support isn't based on assumption, it's based on accountability. The law says support must go to the person who actually cares for the child day to day, meaning the one paying for food, utilities, school, medical needs, and household essentials. If the daughter lives with the grandmother, then logically, she should be the one receiving the funds. But the ex-wife claims she has receipts, yet receipts only matter if they match the type of expenses required by custody law. So is this a misunderstanding? Or was someone comfortable receiving money they knew wasn't meant for them?
Okay, that's called parenting. That's not child support.
Well, I'm using his money for the kid.
But the child does not live with you, correct?
Because of him.
That wasn't my question. The child does not live with you, correct?
Yes, that's correct, Judge.
Okay. Where is it that you are working right now?
Right now I am an office manager at Walker's Dentistry.
Manager? Okay.
That's what I do, Judge. I'm an office manager right now.
Okay. And how much is it that you make a year?
Maybe about $70,000.
$70,000. Okay.
And I'm also a single mother.
Okay.
Here's where the case really turns. The ex-wife proudly announces she's been keeping receipts, expecting that to prove she's been responsible. But when the court asks what those receipts are for, they're revealed to be clothing and personal shopping, not groceries, not school costs, not housing contributions. Child support is legally defined as covering the child's essential, ongoing needs. Clothing is allowed, yes, but only after primary expenses are secured. It doesn't replace the cost of raising a child day to day. So the judge immediately recognizes what's happening. The support payments are not aligning with the child's real living situation. The tone shifts from emotional argument to legal correction. Do you think this was innocent confusion, or was someone enjoying financial convenience?
Well, congratulations. There are a lot of single mothers in this world. So that's not information that we need in terms of calculating child support, okay? How many children do you have?
I have a total of 3. I have 1 with Mr. Walker, and I have 2 with my previous husband.
Okay. All right. Continue. What is
everything
your
was-
reason for this child living with his mother and you're receiving child support payments? And according to your testimony, you're giving the money to his mother.
This is a classic moment you see often in family court. When the financial logic weakens, the ex-wife shifts to emotional appeal, saying, "I am a single mother." But the judge responds firmly, being a single parent does not exempt someone from financial responsibility.
Is that correct information? Is she giving the money to your mother?
That is incorrect, Your Honor.
Is your mother here today?
She is not. My daughter's actually home sick with the flu. So she's at home with my mother right now.
Okay.
Judge, our daughter Kayla was living with me, and Blaine decided to come get her on the weekends. You know, everything was perfectly fine. She was getting along with the other kids in the house. So when Blaine started to come pick her up, and by the time he dropped her off, she would become so angry. She was fighting the other 2 kids. So I don't know if he was telling her things, but she would come back very...
Ma'am, that's more information than what I need.
Okay.
The bottom line is this. The child does not live with either of you.
The law doesn't calculate support based on who has the harder life, but on custody, income, and need. The judge doesn't dismiss her struggle, but she does not allow emotional narrative to replace factual evaluation. This is where the court must separate sympathy from structure. And it's not easy, because in real life, everyone does have their own challenges. But child support must stay rooted in fairness, not feeling. Do you believe the judge handled this respectfully, or should more compassion have been factored in?
Correct?
Correct, Your Honor.
And you're paying child support currently, but to Ms. Walker.
Correct.
And Ms. Walker, you are not paying child support at all.
No,
correct?
ma'am, I'm not.
Okay. So this is what we're going to do. You said you make $70,000 a year. Does that include any overtime or anything?
That includes overtime. Yes, it does.
Okay. Okay. So I have your gross at $5,833.33. Now, after taxes are taken out, that comes down to $4,625.06. Who pays health insurance for the child?
Blaine
I do,
does.
Your Honor.
Okay. How much is health insurance?
For the past year, I've been paying $50 a month.
Okay. How often are you?
I get paid once a month.
So $25 a month. Okay. And then you said you have 2 other children
And I
one
pay
child.
mortgage and car note. And
Ma'am, he has the same expenses. That means nothing to me. Ms. Walker, your child support is going to be set at $707.28.
This is the pivotal moment. Both parents openly acknowledge the child has not been living with either of them. That means the custodial home is the grandmother's. And when custody shifts, legally, child support must shift with it. But many families assume verbal agreements are enough, or that temporary arrangements don't require legal updates. Yet, as we see here, the system doesn't automatically adjust itself. Someone has to bring it to the court, just like Mr. Walker did. Without modifying the support order, money will continue to go to the wrong person, even if everyone knows the situation changed. So the deeper reflection is this: should families rely on informal trust, or should every change, no matter how small, be made official? What would you do in your family?
That includes the $682.28 for child support and $25 for health insurance. Mr. Walker, your $500 payments will be reallocated to you. And as I stated, Ms. Walker, that $707.28 will go directly to his mother as well, since that is who the child is living with. Am I right?
Yes, Your Honor.
Okay, is there anything else from either of you? If nothing further, you all are dismissed.
The judge's ruling realigns everything. The $500 Mr. Walker was paying will now go directly to the grandmother, the person actually raising the child. And the ex-wife, based on her income and legal responsibility, will now pay $707 a month toward her share of support. This decision isn't about punishment. It's about balance and accuracy. Child support is not designed to benefit the parent. It's designed to sustain the child's life where the child actually resides. The lesson here is clear. Child support follows the child, not the parent, not the past arrangement, and not sentiment. So what do you think? Was the judge fair, firm, or could this have been handled differently? And if cases like this interest you, make sure to like, comment your take, and subscribe for more real courtroom breakdowns.